Afternoon, everyone. Special thank you to our guest speakers for being here today. Welcome to the Peel PACEC Practical Solutions Series, focusing on special education disputes with a deep dive into special education due process hearings. I'm Dr. Constance Little, a former Pennsylvania Special Education Hearing Officer and Appeal Panel Officer, a board member of the Pennsylvania chapter of the Council for Exceptional Children, or PACEC, and a staunch advocate for students with disabilities and their families. This is the first session in our second Practical Solutions Series season, which is the continuation of a multi-year collaboration between PACEC and the Peel Center to bring special education professionals, families, and self-advocates together to improve learning outcomes for children and students with disabilities. If you'd like to see last season's sessions, the first one was on transition and the second on universal design for learning. And the recordings are available for on-demand viewing on the Peel and PACEC websites, which we'll be putting in the chat box for you. Our guests today have graciously agreed to have the session recorded as well. So this link will also be available on those two websites. The hearing officers will entertain your general questions regarding special education, dispute resolution, and due process hearings. And we invite you to type those questions in the Q&A section at the bottom of your page, and our moderators will read them for the presenters. The transcript or closed caption has also been enabled. You can add this closed caption by clicking on the live transcript or CC button at the bottom of the screen. And at the end of the session, we'd like for you to stay just for a few minutes so that we can share some announcements and a brief survey. As we turn now to our featured guests, hearing officers Kathy Skidmore and Brian Jason Ford, I've asked them to please share a little background about themselves as we get started. Thank you again for joining us. Kathy.
Thank you, Connie, and welcome everyone, and thank you for joining us today. My name is Kathy Skidmore, and I have been a full-time special education hearing officer for 12 years. And before that, I was an appellate hearing officer along with Connie Little and many others for a period of 14 years. And in the meantime, I also had a brief period where I was a special education mediator. I do have an undergraduate degree in special education, so I've remained interested in special education even after I went to law school and graduated. I wanted to remain active in the field, and this has been a very rewarding opportunity to remain active in the field. And special education due process is very active in Pennsylvania, and I am proud to be a part of it. Brian?
Yeah, hi, my name is Brian Ford. I'm also a hearing officer. I've been a hearing officer for the past 11 years, although I still feel like I'm new to the job. I was a special education attorney before becoming a hearing officer. I spent a period of my career representing families of students with disabilities. I spent a period of my career representing school districts, IUs, VOTEX, and I've practiced both here in Pennsylvania. Since I engaged in that practice, I thought that being a hearing officer and sitting in the middle was a better place for me. And I was honored and delighted to become a hearing officer 11 years ago. So that's us. I should say before we do anything else that we welcome your questions. We encourage you to use that Q&A feature. The more time we spend answering your questions and tailoring this presentation to what you have in mind, the better we're doing. That being said, we are somewhat limited in what we can answer. You can ask us anything, and don't be shy about that. But we cannot give advisory opinions. We can't tell you what we would do in your case. And there's no difference between saying, I have a student in situation XYZ. What would a hearing officer think about that? And hypothetically, if there were a student in situation XYZ, what would a hearing officer think about it? Hypothetically is not a magic word there. So we are more than happy to answer questions about process. We are more than happy to answer your general questions about due process, questions about the work of hearing officers, special education law questions to the extent that we can, but what we can't do is give you advice about your case. Anything to add there, Kathy?
No, I think you covered it though. Thanks, Brian.
Okay. We do have some slides prepared, not a lot of them, but we wanted to start by giving you sort of an overview of what ODR is. ODR is the Office for Dispute Resolution. It's the state entity that Kathy and I both work for. And we can tell you a little bit about that and what our process is. So I'll share my screen to start that slideshow. I think we can get past the title screen pretty quickly here. And we could do that faster if I could see my mouse. There we go. Okay. The Office for Dispute Resolution administers the special education dispute resolution system in Pennsylvania, and that includes more than just due process hearings. ODR offers a continuum of services for dispute resolution. Everything on one end from the special education consult line all the way to a due process hearing. You see them on opposite ends of this continuum here because due process hearing is the most formal, most court-like proceeding along that continuum, and special education consult line is probably the least formal means that we have here. We can run down this continuum, starting with the consult line. The consult line is what it says it is. It is a number for parents and non-attorney advocates to call to get guidance on special education issues. If there is a question about what an IEP is, sort of broad-based, or I'm having a dispute with my school district, what are my options? Someone who has training and background in special education dispute resolution is there to answer your questions. They've just made an update to the ODR website where there's a chat feature that will do the same thing. And I think that there's an email to the consult line as well.
The consult line is, as Brian said, it's an information sharing service that is available. It also includes a family engagement service, and you can take a look at the consult line portion of the ODR website for a better description of what all that entails, but they do offer a variety of services designed to get information, especially to families, about dispute resolution in Pennsylvania. One thing that they do have a process that may not be widely known that is available in some unique circumstances called the call resolution process. So that's sort of like a first step in actually getting to working with parties or helping parties to try to reach a resolution ahead of anything formal being filed or anything formalized being entered into. So that's all part of special education consult line. It's a toll-free number, or also, as Brian mentioned, available through chat and also we think by email.
And we now see a direct link to the consult line section of the ODR website. Actually, no, I'm sorry. It's not that. It is an information page about the consult line posted in the chat. One website to keep in mind is the ODR website. That's odr-pa.org. You can get more information on anything that we're talking about at that website. There are wonderful resources there, both for parents and for schools that sort of explain what ODR is, what services we offer, and everything from copies of hearing officers' decisions and links to regulations to the consult line chat box. It's all there.
Just one word of caution, the consult line specialists are not able to answer specific questions, are not allowed to offer interpretations of, for example, what the legal terms are, or offer any type of advocacy or advice. So they're information sharing service. They're very valuable. They're very helpful, and they have a vast array of resources available to them, some of which we'll get to later on in the presentation that are also available to you. But again, it's a very good source for information about special education and dispute resolution in Pennsylvania.
The restraints on the consult line, folks, are very similar to these restraints that Hearing Officer Skidmore and I are operating under today. But I think that we can move on to training and education, which, congratulations, now you're all part of. We offer services like this, where hearing officers And ODR staff do go around the state talking about what ODR is, talking about what ODR does, and I think probably most importantly, talking about how parties to special education disputes can resolve their disputes. We are the Office for Dispute Resolution. We're not the Office for Due Process Hearings. We're not the Office for acrimony. What we do is we resolve special education disputes, and you can see that due process is just one thing that we do. And part of our mission is to tell people about that and to tell people all that we do. So you're seeing an example of the type of training that we provide here today. We offer this training to parent groups. We offer this training to schools and school entities. We offer this training to almost anyone who's interested, anyone who would be a stakeholder involved in the system.
And there are a variety of types of training that are available that certainly you can go contact ODR for more information on what is available and how you might be able to get whatever type of training it is that someone is seeking.
Right. Should we move to IEP IFSP Facilitation? I see that there are questions coming into the Q&A. I think that Peel staff is monitoring those for us. I'm glad to see them coming. Please do fill that out as we go through, and then we'll get that from our co-hosts, whatever the Zoom term is. We'll get them as we go. So we have IEP and IFSP Facilitation. Sometimes you'll be in a situation where you're at a team meeting, an IEP team meeting or an IFSP team meeting, and there is some communication issues that are hindering the team from completing its goal of getting to an agreed to IEP or IFSP. ODR can send a third-party neutral facilitator to those team meetings to help the parties communicate with each other. This is not someone who's going to evaluate your case. This is not someone who's going to tell you what you should do. This is something that is directed by the team participants. What the facilitator does is it helps, he or she will help the participants overcome whatever the communication issue is to get to an end product for the student. It's a voluntary process. Everyone has to agree to participate, and ODR arranges for the facilitator only if both parties are in agreement.
It's important to keep in mind, I think Brian alluded to, the facilitator is not a member of the IEP team, will not be giving input into the content of an IEP, but really will serve to facilitate the meeting so that those participants who know about the child's needs and what the child's what needs should be addressed are able to work through that with any communication difficulties. So it can be very helpful to have that extra third person available or present to facilitate the meeting, especially if there's been a breakdown in communication.
Right. And I think that that's a little bit different from the next sort of step on that continuum, which is mediation, because IEP or IFSP facilitation does not presume that there's a disagreement between the parties. It only presumes that there is something standing in the way of everyone getting to a place where they can either come to agree to language for the IEP or some type of miscommunication that a third party can help work out. It does not necessarily have to be a dispute. Mediation is kind of the next step where there definitely is a dispute. Somebody wants something and somebody wants something else. And what mediation is ODR will send a trained, independent, neutral mediator to help the parties resolve the dispute. One of the things that I want to point out about mediation is that mediation can happen as part of a due process hearing, but it doesn't have to. Parties can choose to use mediation instead of going to a due process hearing, before going to a due process hearing, and parties can also do mediation as part of a due process hearing. One of the nice things about mediation is that mediators can resolve issues that you might not be able to bring to a due process hearing. There's sort of no restriction on the scope of what a mediator can tackle. And you can achieve more agreeable results through a due process hearing, through mediation, than you can through a due process hearing. The example that I like to give is tuition reimbursement. In a tuition reimbursement case, under the laws that we operate in, the precedent that we operate under, there's no such thing as I'll give a little tuition reimbursement. You either get it or you don't. In the vast majority of that type of case, a mediator has the ability to have the parties come to an agreement on proportions in a way that a hearing officer can't. But it's not limited to that. You can walk away from a mediation with things that a hearing officer cannot award you that might be more palatable to whoever is giving those things. So please do consider what it is that you're trying to achieve as part of what type of dispute resolution you're selecting.
And just
Brian,
no, go ahead.
sorry, this is Kathleen from the Appeal Center, and I'm monitoring the Q&A. I think one of the questions is this is a great point for it. They have asked, can you give an example of a situation where someone would need mediation, and who requests mediation? Is it the parents or the teachers?
Okay. It's hard for me to think of a situation in which mediation is not helpful or inappropriate. If there is a dispute, I think that mediation is never the wrong choice. In terms of who requests it, anyone can request it. Anyone who's involved in the dispute can request it. Schools can request it, and parents can request it. And just to frame this a little bit, when I talk about a school can request it, we view schools in the singular. We understand that they're not. We understand that a school is a group of people, right? There's teachers and there's administrators and there's bus drivers and there's everyone else involved, okay? But from the point of view of a hearing officer, the school is a singular thing. And so whichever person within the school requests it in a literal sense matters less to us. At the end of the day, someone will be physically filling out the paperwork. Who doesn't matter. But what happens is no matter who requests the mediation, be it the family or the school, the first thing that happens is that ODR reaches out to the party that did not request it and say, do you want to do this? It's a voluntary process. Both parties have to agree. And nothing happens unless both parties agree. As soon as both parties agree, ODR schedules a mediator and the mediator contacts the parties and the mediation is set up and the mediator comes out and mediates. But it's hard to think of a time where that's inappropriate, and it doesn't really matter who requests it because anyone can.
Okay.
It's also important to keep in mind, since we're talking about all of these early dispute resolution options, and I think I would put mediation in that category as well, even though it can be more formalized. We're talking about all of the options that are available where the parties are working to reach a resolution on their own, where they're not getting to the point where they're giving everything to someone else, a hearing officer, to decide it for them. So I must agree with Brian that I can't think of a singular instance where I would say, boy, that wouldn't be a good idea for those parties to go to mediation. There's no criteria that ODR evaluates the request and decides whether or not you can. If the parties both agree, go to mediation. And mediation, again, can be more flexible.
I'll tack one thing onto there. I think that my answer that mediation is appropriate in every case assumes one thing that I just want to make explicit. And that is, we're talking about situations in which the parties are not able to find a resolution on their own. Because the first step in anything is just to talk. There are plenty of situations in which the law bakes in opportunities for informal meetings, and whether or not the law bakes in opportunities for informal meetings, you can do it anyway. We're talking about situations, particularly as we move towards mediation and beyond, where the parties have tried. where there has been an IEP team meeting that didn't go so well, where there is a request to do something and someone saying, no, we're not. We're not talking about situations in which there's been no attempt to talk to each other first. I think that goes before everything else. The vast majority of IEP team meetings do not require facilitation and do not result in issues that require mediation, the vast majority. So we are talking about those situations in which there really is some type of impasse. And in those situations, whatever the impasse is, it's difficult for me to think of a scenario in which mediation would be inappropriate.
Okay, this is Kathleen again with another question. I'm just going to rephrase a little bit because I think it will answer the other question out there is what happens specifically, I think, with paperwork if one of the parties does not agree to mediation? Like, how is that documented since both parties have to agree?
ODR will, if there's a mediation request, ODR will contact the parties and will let you know before the case is closed. If the other party won't agree to mediation, then ODR has to close the case because the mediation is not going to take place, but they will let you know when the case is going to be closed. So ODR does keep records of those things. So those are always available to ODR and probably to the parties if they were to ask, I would imagine. Not to everybody, but to a party might have a question about their own mediation request. I think they would be able to ask. I don't know why they wouldn't be able to find out what the date was of it, for example.
Okay, I think they were looking for a way to have data to suggest mediation was suggested, but didn't happen for whatever reason, for whichever side is looking for that.
Honestly, I'm not sure how that works. However, I will say this. Since mediation is a voluntary process and nothing happens unless both parties agree, it's usually a good idea to talk to whoever's across the table before you make the mediation request. You might talk to the person on the other side of the table and they'll say, yeah, I think that mediation is a great idea. Should you fill out the paperwork or should I fill out the paperwork? And then it's easy. Or you may talk to the person on the other side of the table and they'll say, no, we're not going to agree to mediate no matter what. At that point, you'll either request mediation or you won't. Maybe, and look, that's up to you. But mediation is a voluntary process and voluntary means just that. It does not happen unless both parties agree. So knowing that, it sort of signals that you might want to at least have a conversation, if not about the substance of the dispute, about the method for dispute resolution before anything goes to ODR.
Okay, thank you. Jumping back up to the IEP facilitation, there's a question about how active the facilitator is in a meeting. Do they lead the meeting? Do they only become involved if there's a breakdown in communication? Yeah, more specifically about what their role is at that meeting.
I would think, I have been involved in a couple of IEP meetings where there essentially was a facilitator. The facilitator is not the leader of the IEP meeting. Technically, that person is not even a member of the IEP team, but I think every circumstance is different. Every facilitator is also different. Facilitators are going to be flexible and accommodating and try to see what it is that the parties need and try to meet those needs. I think there's no hard and fast rule that a facilitator does this or does not do that. So that's a difficult question to answer, but I think the best answer is that they are flexible. And if the parties need a facilitator to do something, there usually is a way for the facilitator to help the parties get what they need in order to move on and hold a meeting and hopefully reach an agreement on a finalized document.
In fact, I think the system would break down if there were too many hard and fast rules for facilitation. It is so circumstance specific that you never want a facilitator to say, I always or I never, because then the facilitator might not be able to do what you need in your circumstance. So it may be worthwhile to have that conversation with the facilitator as part of the facilitation process. You know, as your meeting's starting, if you have questions for your facilitator about what they're going to do or not do, talk to your facilitator. You'll know who that person is before they're in the room in all likelihood.
Okay, there's only one other question, but I can read it. I think it's too case specific, but I will let you address that.
Sure.
It says, if an IEP has been created for a child who is actively attending school in person, but the school is not fulfilling the IEP goals, the teachers have been relying and putting on educational responsibilities onto the child's ABA provider. What would the next step be that the parent should take to resolve the issue?
Well, Kathy, do you want to give legal advice?
No, we can't do that. But what I would suggest is that all of these dispute resolution options are available. If a parent disagrees with what the parent believes is happening or understands is happening with the child's special education program, here's the continuum of options that you have. Informal meetings are always available. Sometimes just strengthening the communication between the parties can go a long way. I don't think we can offer a recommendation for a particular case. What would you do next? I don't know. These are the options that you do have available to you. And there is more information available about each one of them on the ODR website. It's very case specific and individual specific, I think.
Yeah, and I think that looking at, there's obviously dispute, right? There is parent wants the district to do something that the district is not doing, according to how I understood that question. Okay, so think about what we've talked about. We talked about these informal meetings and IEP team meetings. What conversations have there been? And I'm sure there's probably lots of email too, because there's always lots of email. What conversations have there been where the parent tells the district, this is what I want you to do? And what has the response been? What informal meetings have there been? Is this a question of poor communication, where the school is not understanding what the parent wants the school to do, or the parent is not understanding what the school is doing, or maybe a little bit of both? Maybe that's a good opportunity for facilitation. If everybody understands everybody else and simply disagrees, maybe mediation is the right next step, or maybe anything else for all the way up to due process hearing is the next best step. But I think what's important is to know what the options are, so that you can choose an option that fits the circumstances that fits your circumstances, I should say, because there are lots of options. We can't tell you what the best option is, and frankly, in most cases, there is no single best option. It's just a question of knowing what options are available, seeing what options you're the most comfortable with, and seeing what can be done to resolve the dispute.
Okay, and there's one last sort of procedural question for right now. Are due process hearings, or I'm going to guess this applies to anything related to the dispute resolution process, are cases scheduled based on the order that they come in or the severity of the need of the student?
You're talking specifically about due process, and we're going to get to that in a few minutes, I think. Once a due process complaint is filed, the federal regulations set forth the timelines within which a hearing must occur and the decision must be issued. Typically, a hearing is scheduled within those timelines. If it's a parent-filed complaint, there's an automatic 30-day resolution period that's factored in. The hearing is not to take place until after that resolution period has ended, or there are certain circumstances where there won't be a resolution period if the parties waive it, for example. In an LEA filed complaint, there is no resolution period. So the hearing timeline is shorter. It's only 45 days for a decision. So the hearing could technically happen the next day after the complaint was filed, and that would not be likely, I wouldn't think. Of course, just because an LEA files a complaint, and there is no resolution period, that doesn't mean that the parties can't decide, let's try and have a meeting anyway and see if we can resolve it. But that's how the hearing dates are set based on what the regulations tell us. We can't schedule based on, if we read a complaint, how serious we think the complaint is, but we have to follow the regulations. We can't ignore them.
That's right. I took a conference call recently in a case where the parent's attorney was asking me to expedite the case. Expediting a case is a special term that we use when certain factors apply and the case goes on an expedited schedule. It looks even faster than the LEA filed complaint. And I had to explain to the parent's attorney that I understand that the issue presented in your complaint is serious and is of an urgent nature. But unless both parties waive the resolution period in writing, the earliest that I can convene is 30 days from the date that the complaint is filed. So it's not in terms of first filed. The filing date is often controlling. So if that to you means first filed, it's not how I view it, but I can see how you could get there. It really is all controlled by statute. That's at the due process level. In terms of the other dispute resolution options, that is usually something that is worked out between the parties and either the facilitator or the mediator. There's not that strict statutory timeline that applies to those other processes. ODR maintains a list of qualified mediators and a list of qualified facilitators, and they work all over the state. So it really comes down to the mutual scheduling of the mediator or facilitator and the parties to work that out. We can pause here for more questions, or we can move on to the next spot in the continuum. I'm happy either way.
I think since we're getting some questions about due process, it wouldn't take us long, I don't think, to just go through those last few options on the continuum as a suggestion, unless there's something that's...
Yeah, no, you've answered most of there's only one other question so far. So I think continuing is a great idea.
Okay. That brings us to resolution meeting facilitation. We just spoke about the statutory resolution period. One of the things that happens during the statutory resolution period is a resolution meeting or resolution session. Those resolution sessions are required by law. In fact, we cannot convene the due process hearing until that resolution session happens, unless it's waived. So one of the things that ODR can do is it can send a facilitator to that resolution meeting. And that facilitator does essentially the same thing that a facilitator does at the IEP or IFSP team meeting, where they're enabling the parties to communicate with each other. They're not directing the outcome. They're not saying what it is that the parties should or should not do. They are simply helping the parties to talk. So you have to be in that meeting anyway. If you're at the point where you've already requested a due process hearing, perhaps communication has already broken down, and a facilitator can help restore that communication that has been broken down.
And again, resolution meeting facilitation is only available after a due process complaint has been filed by a parent, because the resolution meeting is required. It's an option that ODR offers that's not necessarily mandated by the IDEA, but it can be a very helpful tool for parties when they have reached that stage. I just want to remind everyone, the majority of special education disputes do resolve amicably by the parties. Even if you get to this stage where you're at the resolution meeting, of the number of due process complaints that are received by ODR in a given year, the vast majority, somewhere between 85 and 90%, resolved by the party. So just because a complaint's been filed doesn't mean it's too late and it's not worth even trying to work it out, because usually that is exactly what happens.
That's correct. It cannot be overstated that often requesting a due process hearing is the start of a conversation and not the end of it. So the resolution meeting is a statutorily required part of that conversation. But I would encourage anyone involved in a due process hearing to not simply go through the motions. There is value in the resolution meeting. And sometimes that resolution meeting doesn't look like a meeting. Sometimes that resolution meeting is a series of conversations between the parties or a series of conversations between the parties' lawyers. And oftentimes that is highly effective. But when it comes to actually sitting down in a room and talking to each other, there's value there. And if communication is problematic at that point, having a facilitator there can be a wonderful method to help get the parties past their current dispute. Next, we have the Hearing Officer Settlement Conference. We love acronyms. Acronyms are our favorite. So you'll hear us talk about HOSC or HOSC. That's a Hearing Officer Settlement Conference. This is also available in the context of a due process hearing where the parties can and I think it's available beyond a due process hearing too, but it is on the more formal side, which is why it's on this end of the continuum. The parties can say, you know what, we don't think that a typical mediation is enough here. What we want is a hearing officer, someone like Kathy or me, to come in and help the parties resolve their dispute. Most often this happens in the context of a due process hearing. If it happens in that context, the hearing officer assigned to the settlement conference will be a different hearing officer than one assigned to the case, because the hearing officer who's assigned to the case shouldn't know too much about the substance of the settlement negotiations. We also assign a hearing officer who doesn't have other cases pending in the same district, if at all possible. So schools don't have to worry about disclosing too much information that might bleed over into other cases. I love doing these. I really do. I think they're incredibly helpful. Our settlement rate coming out of hearing officer settlement conferences is quite good, but it is more formal than mediation. And frankly, it tends to be more directive than mediation. A mediator will never tell you in a facilitative type of mediation what outcome the parties should be shooting for, or what the outcome of the case ought to be. A hearing officer settlement conference, I am inclined, at least when I do them, to break the parties out, talk to the parties separately, and sort of say, what is it that you are trying to accomplish? And where is it that you're willing to give, and what are you standing firm on? And I do that with both parties, and I never reveal anything to the other party without their permission, but it's far more evaluative, far more directive. And sometimes that's what's needed to break up a logjam in a case.
And it's important to think of this hearing officer settlement conference as an option, not at the very beginning when the parties have not even spoken with each other, but they just want to put the whole thing in the lap of the settlement hearing officer and say, one party says this, the other party says that, and the settlement hearing officer is trying to sort out what would be a huge evidentiary record and offer some possible outcome based on his or her experience. That's not what it's all about. That's simply too difficult, and that would essentially ask the settlement hearing officer to speculate what he or she thinks the outcome will be if you go forward to a hearing. So that's really not the purpose. We're looking typically in these situations, the parties have gotten so far in their discussions, but maybe one party won't give on this and the other party won't give on that, and there's no meeting in the middle. So the hearing officer can take them hopefully past that point with some insight from the hearing officer perspective that kind of helps them get over the hurdle that won't get them to that final, yes, we do finally have an agreement together.
Yeah, and there was a question before about when would mediation be inappropriate, and I sort of said, I did say, not sort of, that I can't think of a situation in which mediation would be inappropriate, assuming that we're talking about parties that are at some kind of impasse where we're just talking to each other without the help of a mediator, couldn't get past it. I think that there are some situations that don't work as well for hearing officer settlement conferences. Hearing officer Skidmore said that these tend to come at the end where there's something really creating impasse. And I completely agree. When I'm assigned to these, I tend to ask two questions at the beginning. What is it that you've already done? You know, what have you already done to try to resolve this dispute? What conversations have you had with each other? Has there already been a mediation that has failed? Has there already been some type of facilitation that has failed? You know, and if the answer is nothing, we're going to have a very different kind of conversation. But then after that question, I tend to ask, what's the logjam? Not what is that you're trying to accomplish. I don't want to know the background of your case. I don't want to know, you know, your theories and your legal theories or all the minutia of the facts. I want to focus on whatever it is that's keeping you from settling. Is there some number that you can't agree to? We're going to focus on that like a laser beam. Is there some program that's the issue here? We're going to focus on that. And we're just going to break through these log jams one at a time until we're able to resolve the case.
And very often it's effective, even if they can't reach an agreement on everything. A lot of times a settlement conference can at least narrow the issues down that likely will go forward to a hearing and a hearing officer's decision.
Which brings us all the way to the end of due process. Kathy, what do we want to say about due process?
Well, again, due process is a mechanism that's required by the IDEA, as is mediation. It has to be an option along with their other options, such as the state complaint process. But due process is an option for parties to a special education dispute involving certain matters under the IDEA. Our jurisdiction is limited to special education matters and discrimination claims. In certain instances, we don't have jurisdiction over global systemic district-wide policies, for example. But we are able to issue decisions and accept jurisdiction over a case involving certain issues in special education due process. They are contentious. If you think about a lot of the continuum, they're more contentious in some respects than most of the other options. Not necessarily that the proceedings are contentious, but the parties are on one side or the other. So there's one side against the other. They're more like a court proceeding than they are any of the other options we talked about where the parties are trying to work together. Here, you're going to give evidence to the hearing officer through witness sworn testimony and documents that are referenced as exhibits, handing that all over to the hearing officer and saying, here, you figure this out. So you're relinquishing all control over what the outcome of the case is going to be.
And that last point bears reiteration. So many people who describe themselves as type A also say that they like due process. I'm here to tell you that those things are incompatible. If you like to be in control, if you like to dictate outcomes, due process is not the right process for you. Because what you are saying by requesting a due process hearing is, I know what I want the outcome to be, but I'm going to let Kathy Skidmore or Brian Ford decide what the outcome is. And there are plenty of instances where it does get to that point. My full-time job as a due process hearing officer on a proportional per capita basis, Pennsylvania has a lot of them. But I think that the biggest misconception about due process is this is the mechanism by which I achieve a particular result. It's not. It is due process is the mechanism by which you leave the result to someone else. You present your evidence, you present your arguments, and then you let someone else decide. So if you are the type of person who likes to be in the driver's seat, you should know that going in. And I'm not trying to discourage anyone from requesting a hearing. There are plenty of circumstances in which due process hearing is exactly what's needed. And you've heard us say, I think that 90% might be even too low. The overwhelming majority of due process complaints that are filed do not result in a hearing officer telling the parties what to do. They result in the parties coming to a table to resolve their dispute through some other means, be it facilitation or mediation or a hearing officer settlement conference, or simply just talking to each other. That's how that's how almost all of these go. Sometimes requesting the hearing is the catalyst for that. Sometimes it's not. But when it is the option of last resort, though. It's the option where you say, I'm going to let someone else do this. I'm going to let someone else decide.
And maybe we should just go quickly to the next slide and then turn to questions. I think this might answer some of the questions. What resources are available to me as someone who may be considering mediation or due process or one of the other options. Especially if you're considering a due process, there are a number of resources on the ODR website. There's a 4-part video series by the hearing officer about the hearing process. There's a parent guide to understanding due process that is available. Again, ConsultLine is a resource if you want to know what the regulations say about this or that. They can provide you with that information. So there are a lot of resources on the ODR website. And again, that chat function, if you can't find what it is that you think should be there, send a chat question and you should get an answer pretty promptly, just as we're used to in many other websites. The pre-hearing directions that all of the hearing officers follow are available there. So that's something to be familiar with. All of those types of things are available on the ODR website. Again, odr-pa.org. And with that, I think I'm seeing the number of the question and answer go up. I'm not looking at the questions, so I'm just seeing the little balloon that's showing me that we do have quite a few new questions. Brian, did you want to add anything to the resources?
No, but I would keep that website handy. I just changed the slide to show some additional ways to reach out to ODR. The website is best. We do, if you rely on, if you use TTY, PA Relay 711 will work, but you can find a lot of information on that website, much more than what we covered here.
One of the questions that came up is whether or not attorneys are permitted to attend mediations now, and whether or not you're required to have an attorney for a due process hearing.
The first is yes, attorneys can attend mediation now. That is a recent development. My understanding, and Kathy will correct me because I might be wrong, is that the LEA can bring an attorney only if the parent also brings an attorney. But attorneys used to be not allowed in mediation, and now they are allowed in mediation if everyone's coming with an attorney.
And that's Pennsylvania specific. Other states do permit attorneys at mediation. But yes, the mediations are just like the resolution meetings. If the parent does not have an attorney, then the LEA is not able to have an attorney participate either. And with respect to due process, it's not a requirement that a parent be represented. LEAs are always represented by an attorney. They're required to be represented by an attorney in Pennsylvania. Parents are not required to have an attorney. They may represent themselves. We do cover this in our 4-part video series, but parents certainly have the option if they don't wish to or for some reason cannot obtain counsel. The procedural safeguard notice, general and NORAPs typically have a list of resources that should be available to help parents find legal representation and other information if interested. But no, it is not required that the parents be represented by counsel.
And one of the other questions was about getting the translated material found on the ODR website, how ODR supports parents who speak different languages to understand the process, such as mediation and due process and any other process for them to participate, who's responsible to provide an interpreter for these processes, and who's responsible to translate the agreement, and how long would it take a parent to receive a translated document?
Well, first, let's just clarify some terms, because interpretation and translation are not the same thing. Interpreters if there is a need for an interpreter for a parent to participate in a due process hearing, ODR provides an interpreter. I will tell you that retaining an interpreter for a due process hearing is not a simple thing. And if we're at the end of the slideshow, I'll just stop sharing my screen. It's not a simple thing. So the moment you know that an interpreter is needed, you need to tell ODR. If you are the person who needs an interpreter, or if you are representing a person who needs an interpreter, the request should be made in the complaint itself, right at the top in bold on a separate line. Make sure that we can't miss it. If you, the most common example, but it's not the only example, would be if the school requests a due process hearing against a parent who needs an interpreter and the school, for whatever reason, does not include that information in the complaint. If you are the parent who gets that, or if you are the person representing the parent who gets that, we need to know right away. And then we can go about the business of securing an interpreter for your due process hearings. I have 3 hearings scheduled as we sit here today, all involving interpreters of different languages. So that is a service that ODR provides. For translation is different. Translation, we're not talking about spoken word, we're talking about documents, converting a document from one language into another. I believe that ODR offers resources on its website in several languages, and there are ways to convert the ODR website itself into several different languages. So that is the place to start.
Okay, somebody had a question about clarifying where is the family engagement project in the continuum process?
Family engagement services are part of Consult Line. It used to be 2 separate titled services, but it's all folded now under the same umbrella. So anything that the family would need in terms of family engagement, the same process of contacting Consult Line applies. They all also handle family engagement services.
Okay, there's 2 other questions. I think, again, they're a little too specific for you to answer, but I'll throw them out there for you. Our school district accepted the evaluation from another school district in the fall of 2019. We are due to have a reevaluation in April 2020. Is it too late to request an IEE?
Brian?
They're speechless.
Well, no. We're speechless because we want to be helpful, but I hope that you appreciate that we're walking a very fine line here. There is a difference between procedural guidance, which is how we help parents who are involved in due process that don't have a lawyer. Explaining what the hearing is, explaining what's expected of them, what they have to do to prepare documents, to call witnesses, that sort of thing. We can provide a lot of assistance in that regard. What we can't do is do anything that is legal advice. Like we're not in a position to tell you what your rights, how to go about enforcing your rights. Okay. Because we're the people who decide whether or not those rights have been violated. We have an ethical obligation to stay out of that. I will tell you that there are a number of ODR resources for families and for parents that do some work in explaining parent rights. That is the type of question that can be passed to the consult line, because what the consult line can do is they can share the statute. They can say, hey, you've asked about a reevaluation. This is in a literal way what the IDEA has to say about reevaluations. They can't interpret that language for you, and lowercase interpret. They can't. I'm not talking about reading that text in a different language. I'm saying explaining what that text means, because sometimes the laws and regulations are subject to the interpretation of courts and precedent and all that kind of stuff that we're not going to get into today. But questions about what does the law say about X? In a literal sense, that's the perfect question for the consult, as I understand it.
So I think that's a great place for us to now just come full circle right back to the consult line where we all started. So thank you for that question and thank you for that answer. And thank you for your time and your expertise today. Hearing Officer Brian Ford and Kathy Skidmore. We really appreciate it. Guys, everyone, please hang out for just a few minutes. We do have a survey and we have a couple of things that our PACEC President, Brooke Lilo, will be sharing with you momentarily. Again, thank you for a wonderful session. Wow, so much information and it was so helpful. Thank you, thank you, thank you. Brooke?
Thank you for having us.
Thank you very much. It's been a pleasure.